The second panel is entitled Constitutional Litigation, and the moderator is Adam Skaggs, who you can see on our screen. Adam is the Chief Counsel and Policy Director for the Giffords Law Center. And that is one of the leading nonprofit organizations in the firearms litigation space. Before joining Giffords, Adams worked at Everytown for Gun Safety and at the Brennan Center for Justice here at NYU. Adam clerked on the Eastern District of New York and on the 11th Circuit. And like Abby, Adam is also affiliated with Paul Weiss. Please welcome Adam, and he will introduce the members of his panel.
Thank you, Peter, for the kind introduction, and many, many thanks to you and David for putting this terrific event together. And thank you to all of the institutes, all the centers at NYU, obviously, as well as Duke and Yale for sponsoring this terrific event. We have a great panel that's coming up. Hard act to follow. I thought the first opening panel was terrific and very very interesting and thought-provoking. I am confident that our discussion now will be as well. And I'm grateful that General Tong, in his initial remarks, referred to the Heller and McDonald cases and some of the leeway for particularly state-level regulation of firearms to continue. Obviously, as we've heard from Tim and others, there's a great difference in the way that states across the country approach guns, and the different policies that have been enacted have obviously given rise to a number of cases making their way through the courts in the years since Heller and McDonald were decided. And so our discussion for the next hour and 15 minutes or so is going to take a deep dive into some of the constitutional questions that have been litigated and that are being litigated. I would just take a quick moment to observe that while most of the litigation that we'll be talking about is Second Amendment litigation, testing the contours of the Second Amendment and how courts are interpreting that, that's not the only type of constitutional litigation or the only constitutional provisions that are implicated in gun litigation. We've seen takings clause challenges to various laws that attempt to regulate or prohibit particular types of hardware. Let's say the federal bump stock ban, that's been challenged on takings grounds, as well as some other cases. We've seen due process claims addressed to various different gun laws, in particular the types of laws that allow courts upon a finding of dangerousness to remove firearms or prohibit firearm access by somebody who has been deemed to be a danger to themselves or others. So there are other constitutional provisions that do come into play when you talk about gun litigation. I think it's important to note that, though, again, most of our discussion will center around the Second Amendment. I am eager to get right into the discussion here from our panelists, so I don't want to take too long in going over their credentials and their backgrounds, but I will just introduce them with their titles and affiliations in the order that we're going to from them. And as with the first panel, we'll hear some initial remarks from the panelists, about 7 to 10 minutes. We'll then go into a bit of a roundtable discussion and finally try and save as much time as we can for Q&A. So in the order in which they will be speaking, we'll hear first from David Kopel. David is the research director, Independence Institute, and he teaches constitutional law at the University of Denver's Sturm College of Law. After we hear from David, we'll turn to Deepak Gupta. Deepak is the founding principal of Gupta Wessler, where he focuses on Supreme Court appellate and complex litigation. And Deepak has been counsel in numerous cases, both to amicus parties, in particular Everytown for Gun Safety, as well as representing some parties that are directly involved in litigation. Next, after Deepak, we'll hear from Bob Cottrell. Bob is the Harold Paul Green Research Professor of Law at George Washington University Law School. Then we'll turn to Marian Franks, who is a Professor of Law and the Dean's Distinguished Scholar at the University of Miami School of Law. And finally, we'll close it out hearing from Joseph Blocher. Joseph is the Lanty L. Smith Professor of Law at Duke Law School. So it's a terrific panel. Really looking forward to the discussion. And with that, I'll turn it over to you, David. I think you're on mute, David. Still on mute, it looks like.
All right, am I off mute now?
There, now you're good to go.
All right, very, very exciting. Good afternoon, and thank you for your patience. So today, many lawyers have a practice that involves right to arms constitutional litigation, but it wasn't that way in the 19th century. Then, most constitutional arms rights arguments were just brought by individual lawyers whose client happened to have a legal issue involving the right. For example, a client was being criminally prosecuted, or a client's firearm had been seized, and the government action arguably violated the Second Amendment or similar state provisions. The first true Second Amendment litigator, in the sense of bringing test cases, was Lyman Trumbull of Illinois. He started out in the 1830s as the leading anti-slavery lawyer in that state, bringing the cases that constricted and then terminated the enslavement of persons descended from slaves held by the French colonial settlers. Trumbull later served as a justice of the Illinois Supreme Court. Then, as United States Senator, he wrote the 13th Amendment, the Civil Rights Act, and the Freedmen's Bureau Act. The latter two were expressly intended to protect the Second Amendment rights of former slaves, especially for self-defense against terrorist gun-grabbing organizations such as the Ku Klux Klan. In Trumbull's view, the 13th Amendment power to abolish all the badges and incidents of slavery was fully sufficient for Congress to protect the right to arms nationwide. After leaving the Senate, Trumbull became one of the nation's top Supreme Court attorneys and the first right to arms repeat litigator. He argued Dunn versus Illinois before the Illinois Supreme Court in 1879 and Presser versus Illinois, excuse me, before the US Supreme Court in 1886. These test cases unsuccessfully challenged a statute restricting armed parades to only those politically approved by the governor. The plaintiffs were leaders of an immigrant socialist fraternal association. Near the end of Trumbull's six-decade career in the 1890s, he represented imprisoned railroad union leader Eugene Debs before the US Supreme Court. Assisting Trumbull on that case was his young protege, Clarence Darrow. Trumbull's final act Trumbull's final act on the public stage was writing the 1894 platform of the People's Party, usually called the Populists. Resolved, that the power given Congress by the Constitution to provide for calling forth the militia to execute the laws of the Union, to suppress insurrections, to repel invasions, does not warrant the government in making use of a standing army in aiding monopolies in the oppression of their employees. When free men unsheath the sword, it should be to strike for liberty, not for despotism, or to uphold privileged monopolies in the oppression of the poor. In the latter half of the 19th century, no other lawyer did so much on behalf of arms rights as Lyman Trumbull. Yet Trumbull was not a gun guy. His lifelong cause, in the words of Clarence Darrow, was the poor who toil for a living in this world. As Trumbull saw, the rights of the toilers could always be trampled unless they had the right to arms, individually and collectively. That was true for Black people in Mississippi in 1866, and it was true for immigrants in Chicago in 1886. Today, constitutional rights litigation on all topics, including the right to arms, is much more sophisticated than it was a century and a half ago. One useful purpose of amicus briefs is to present courts with perspective and expertise. My practice often represents law enforcement officers, such as the National Sheriff's Association, Colorado Sheriffs, Law Enforcement Training Organization, and others from Maryland to San Francisco. They are the brave and the bold, the men and the women who run toward the sound of gunfire. They certainly understand the deadly perils of firearms in the hands of criminals. They also know that when seconds count, the police are usually minutes away. They understand that almost every victim of a violent criminal attack must be his or her own first responder. Like the large majority of American law enforcement officers, according to Pew Research, my clients reject the notion of banning arms by labeling them assault-style weapons. They don't believe that standard 11 or 17 round magazines for common handguns are weapons of war, supposedly made for mass carnage. In fact, such arms are carried routinely by ordinary police officers or sheriff's deputies. The only reason peace officers carry weapons is for the lawful protection of self and others, not to inflict mass carnage. Americans have always looked to law enforcement officers for good examples in selecting appropriate arms for lawful purposes. That was true for Colt revolvers in the 1880s and for Springfield pistols today. Unlike in police states, American constitutional values draw a strong line between civil law enforcement and the military. In the American law enforcement tradition, equipment such as machine guns or flashbang grenades is generally and properly restricted only to special units involved in very high-risk operations. In my client's view, the typical arms of ordinary law enforcement officers, such as standard magazines and mainstream handguns, rifles, or shotguns, should be lawful choices for citizens for precisely the same reason they are the common choices of typical law enforcement officers, because they are the best arms for lawful defense of self and others. Most law enforcement officers do not want innocent victims to be forced to try to defend themselves with inferior arms. As my clients explain, the defensive value of firearms is not based solely on how many shots are fired in an encounter. Rather, when potential victims have the capacity for effective defense, that capacity is often sufficient to prevent violence in the first place. That was true in the Lewis and Clark expedition, which carried the 22-shot Girandoni rifle. Judicious demonstrations of that rifle ensured that the small expedition was never attacked, despite being always outnumbered. It was true in the 1890s, when Ida B. Wells and other civil rights leaders urged that every Black home contain a Winchester repeating rifle as a deterrent to lynch mobs. Indeed, after Black people in 1892 did brandish arms to successfully deter a would-be lynch mob, the white supremacist state legislature the very next year enacted the first American statute against repeating arms. This year, we have seen many examples of victims and their allies who deterred looters, arsonists, and violent mobs from destroying small businesses. The defenders and their allies were people of all races. By possessing appropriate arms, they kept the peace, at least in the small business they could credibly defend. This year has seen a lot of vilification of law enforcement officers, as if all of them were guilty of the criminal acts of a very few. At the Independence Institute, we support our local sheriffs and the vast majority of law enforcement officers who are not racist, who do not use unlawful force, and who do support the rights of all law-abiding Americans to keep and bear the reliable arms most suitable for lawful defense of self and others. Thank you.
Thank you, David, for kicking us off and ably squeezing a couple of 100 years of history into just under 10 minutes. So appreciate you taking care of that. Let's turn now to Deepak Gupta, who I think can give us some perspective on looking back past that long history to what's happening today and what some of the trends and developments he's seen in contemporary gun litigation. Thank you, Deepak.
Hi, Adam. It's good to see you. And thanks to Yale and Duke and NYU for organizing this. It's nice to see some familiar faces today as well as some new faces. And I don't know, for me, the big fun of conferences is to see people. And so I'm sorry we can't all see each other in person. I am not going to try to do quite as comprehensive a tour of the history as David, although I'll try to say a few words about what I think the relevance of history will be to Second Amendment litigation in the Supreme Court, especially going forward. But I just want to make clear that I'm coming to this topic as a litigator. So at the risk of taking things from 100,000 feet down to 10 feet, I want to talk about where I see things going with the new court. And I think this is a terrific time for us to be getting together to talk about this, because the Second Amendment is a right that was kind of set in motion, sort of like the deist clockmaker God set something in motion, and then the Supreme Court has not defined its scope or its methodology for a decade, to the increasing frustration of many who would like more robust Second Amendment protections. And I want to just distinguish. I think that the Second Amendment exists. There are sort of different Second Amendments. There is a symbolic Second Amendment that has very important cultural significance to a lot of people, which I think Marianne is going to talk about, that has political significance. But I think at least until now, there's been a thinner Second Amendment, if we think about the Second Amendment in terms of the operative legal rules that the court has produced. The one operative legal rule we know is that there can't be a complete ban on handguns in the home, right? Heller tells us that. And we don't know very much else. In 2016, the Supreme Court decided a case called Caetano versus Massachusetts, in a per curiam opinion that was about as narrow as it could possibly be, sending a case back down to Massachusetts that involved stun guns. But the case could have been a much bigger case. I think many of us are advocates who are following the case were concerned about that case because it had the possibility to define what the Second Amendment meant outside the home, as well as say something about its methodology. But after Justice Scalia died, the court issued what Justice Alito and Justice Thomas separately called a begrudging opinion. And up until the new composition of the court, a lot of us had spent a lot of time thinking about Chief Justice Roberts's views on the Second Amendment, because he was considered the swing justice. He has not written anything about the Second Amendment. And so in order to determine his views, we have to look at the comments he made at oral argument. We have to make assumptions about his views on constitutional law generally. And then we have to look at the black box of his votes, including certiorari votes. And I think if you go back to Heller itself, the chief's questioning of the advocates in that case made clear that he was skeptical of the kinds of means-ends scrutiny that has come to dominate lower court Second Amendment jurisprudence. He expressed views in favor of some kind of history and tradition-based analysis that would look to analogs to see whether there's a sufficient grounding in tradition for particular law. And we now know that the new justices that have joined the court have perhaps even more sympathy for that view. Justice Kavanaugh, as a judge on the DC Circuit, famously wrote an opinion in Heller on remand, arguing for a tradition and history-based understanding of the Second Amendment, not the scrutiny, the means-end scrutiny-based approach that's been followed by basically all of the circuits. And Justice Amy Coney Barrett, in an opinion, in a dissenting opinion involving felon in possession bans, also made a plea for a tradition-based approach. Now, you can say that these are audition tapes, as it were, for judges who are trying to appeal to the judge pickers in Washington, and that doesn't necessarily reflect how they would decide cases that come before the court. And it doesn't tell us a lot about what that tradition and history-based approach is actually going to look like. What level of generality do you use when you're asking for analogs in determining the historical scope of the right. To what extent does the strong Anglo-American tradition of regulation come into play when you have laws that deal with changed circumstances or modern realities, and for which you can't find precise analogs? And you can read the tea leaves differently, but at least Justice Kavanaugh was clear that this tradition-based approach, in his view, doesn't foreclose flexibility for reasonable regulation. And Justice Barrett insisted that there at least be some indication that the law in question involved dangerousness. And that's how she read the history, is insisting on some dangerousness. But there are a lot of open questions in terms of how they would apply a framework like that. So what I've been working on since I started working with Adam Skaggs on these cases is developing an account of the Anglo-American history that shows that just because you answer the threshold question methodologically and say that history and tradition are going to be relevant, doesn't mean that there isn't a role to play for reasonable regulation. And we've traced, in the example of public carry, we've traced laws going back to the 14th century from the Statute of Northampton in 1328, which regulated the carrying of arms in public places, all the way up through the American common law and good cause statutes that were passed in the 19th century in the United States, as well as municipal ordinances that show that just because you say that history is relevant doesn't mean that you foreclose all sorts of reasonable regulation that may exist. And so I have some optimism. I do think it's inevitable that the court is going to take cases on the Second Amendment. Several of the justices have expressed their frustration that this right has been regarded in their view as a second-class right. And if you count up the votes, just the justices that have expressed that view, either frustration about the second-class right or the view that the court should be taking these cases, you already have 4 votes for cert. And so the speculation is that the justices did not grant those 10 cases this summer, not because they didn't have the votes to grant cert, but because they were sent signals by Chief Justice Roberts that they would not have his vote on the merits. Now that Justice Barrett has joined the court, you have a solid majority both for agenda setting, both for taking up these cases, and I think for deciding these cases in favor of a tradition-based view. What that tradition-based view means and how much regulation is retained, I think, is the big question going forward, and I hope we get a chance to discuss that.
Well, I very much hope the same, Deepak. I credited David for starting us off with 200 years of history in less than 10 minutes, and you've now taken us all the way back to the 1300s. So we've really covered a tremendous amount of ground already. Continuing on that sort of historical theme, I want to turn it over to Bob Cottrell to share his perspectives. Bob?
Yes. Am I on? Can everybody hear me? Okay.
Yep, we can hear you. Thanks.
It's, I'm sure we'll all agree it's great actually to get together for a conference and to give our different points of view. However, Zoom conferences are not quite the same thing, because the great thing is going out and continuing the argument later at dinner or over drinks. And unfortunately, we're not going to be able to do that. Well, I'm going to add more history to our discussion, if I might. And I'm here as a legal historian. I'm not somebody who's been involved in litigation or who's followed the litigation. I am somebody who has written on the Second Amendment, and I'm somebody who is very much convinced of the essential soundness and necessity of having a right to have arms, and its corollary right, the right of individual self-defense and indeed community self-defense. I want to start off with a little detour or digression, which is to discuss legal realism. And I'm probably going to, in fact, I'm inevitably going to be misdefining it and perhaps making it broader than it should be. But I think all of us who have gone to law school or have taught at law school in recent decades have had a narrative in which the legal realists are made the heroes of the history of American law. They're the ones who swept away the sort of stuffy cobwebs of formalism and brought in notions of policy and the use of social science to give a jurisprudence that deals with the law as it really should be, and dealing with contemporary problems, addressing, if you will, the felt needs of the times. And as I said, I think we've all gotten a narrative that stresses the realists to some extent as the heroes of American legal history. I want to push the narrative a bit further back. And I see, as somebody who primarily is a student of race in America, I've seen many episodes where, in fact, I see them as the villains of American legal history. And specifically, I would go back to the beginning of the 20th century and the Supreme Court's Jim Crow jurisprudence, where essentially the Supreme Court eviscerates the Equal Protection Clause of the 14th Amendment and the 15th Amendment, voting rights regardless of race. Now, these I would include, and these frequently are not included in the narrative discussing American legal realism, I would include them in that narrative, or I think they should be included. If we think of legal realism as a doctrine that says the courts are not necessarily shackled to formal legal doctrine, that they should be very concerned with policy issues, and very much indeed use the best science of the day, then I would submit that this court at the beginning of the 20th century was in fact part of the realist community. They were faced with the undeniable reality of the 14th and 15th Amendments. They existed. Everybody knew what they were meant to do. But they were convinced that the 14th and 15th Amendments were constitutional mistakes, much the way many, I think, jurists these days view the Second Amendment as a constitutional mistake. There's the scholarship of the day convinced them that that both amendments were constitutional mistakes. Historical profession, at least with regard to Reconstruction, was dominated by the Dunning School, which basically said that Reconstruction was a tragic era, was a constitutional mistake. Don't bother to go to the library to find these works of the Dunning School. Just simply rent Gone with the Wind, and you'll see the essential thesis played out. Also, this was the era of the apex of scientific racism in America, the year before the First World War. And indeed, we had the popular culture also supporting this view, as seen in the novel The Klansman, or its dramatization in Birth of a Nation. So we have this conflict of a constitutional doctrine on the one hand, and all of the best thinking of the age saying that this was indeed a constitutional mistake. So the question is, to what extent do you give a robust enforcement to this constitutional doctrine? Enter what I call the strange career of Jackson Giles. Jackson Giles is a Black man in Alabama in 1902 who, with a group of other Black men, seek to register to vote, and the Alabama Registrar of Voters simply refuses, says, I'm not registering Blacks. The case gets before the Supreme Court in 1903, and in an opinion authored by Justice Holmes, Oliver Wendell Holmes, the court says the registrar's actions are a violation of the 15th Amendment, but that the court lacked the equitable powers to force the Alabama registrar to enroll the men. The next year, Giles and company sue for monetary damages. This time, Justice Rufus Day authors an opinion that states that either the Alabama registrar's actions were repugnant to the 15th Amendment, in which case they had no legal effect, or they were consistent with the 15th Amendment, in which case there was no constitutional violation. The short of this is, of course, that the court, in effect, was nullifying a constitutional principle based on its own policy predilections, including their view that the constitutional principle itself was indeed a mistake. I think there's a parallel to what has been happening to the Second Amendment in the lower federal courts post-Heller. There have been, of course, a range of reactions in the lower federal courts, with some courts giving relatively robust readings to Heller and to the Second Amendment. The Seventh Circuit and the DC Circuit, for example, have found a right to carry outside the home as being consistent with Heller, the decision in Heller and the Second Amendment. Most courts, though, have given fairly restrictive reading post-Heller. There's the two-part test, which is developed in a number of the courts, which, among other things, has automatically excluded the so-called assault weapons, even though what are called assault weapons would meet Heller's common use test. That is, the definition that I would argue makes sense with respect to assault weapons are semi-automatic rifles with detachable box magazines. These have been in the public's hands, the general public's hands, since 1900. These are not new technologies. And I would argue that doodads, such as pistol grips and bayonet lugs, are simply that, doodads. They don't affect the essential functioning of the rifle. This type of rifle was sold by the millions by the federal government in the form of the M1 carbine to the general public after the Second World War. And there are indeed millions of these in public hands, courtesy of the US government. The weapons of war mantra as a reason to view them differently makes no sense whatsoever. What is a weapon of war? There's no clear line between civilian armament and weapons of war. Should we ban knives because the Army issues bayonets? Probably not. It makes sense to talk about a particular function that a weapon might have, an automatic weapon versus other types of weapons, but simply because it may be found in some military inventory is not sufficient reason to say that it should go beyond the protection of the Second Amendment. Let me assert that the assault weapon, the movement to ban assault weapons, is really compensation for the failure of the movement to ban handguns, which existed in the 60s, 70s, and 80s. That met with a resounding failure, rejected by the public, even in very liberal jurisdictions, and ultimately rejected by the court in Heller. And so the movement to ban assault weapons is a substitute for that, and indeed one that makes less sense than the movement to ban handguns. 4% of the firearms fatalities that have occurred in the United States occur with rifles of all sorts. Much larger percentage, obviously, well over 90% with handgun. What is, how much time do I have?
I think it'd be great, Bob, if you could wrap things up.
Okay, well, let me just say that a couple of cases that I would just very quickly say are an indication of the lower courts not taking Heller and the Second Amendment seriously. I would list cases dealing with New York City in particular, Kwong versus Bloomberg, high fees and extended waiting periods for a premises permit, a right to have a pistol in your home, and New York State Rifle and Pistol Association versus City of New York, restrictions preventing individuals who've gone through a very arduous process of getting a New York City premises permit from taking their lawfully licensed pistols to locations out of state, either for second homes or for ranges where they could lawfully practice outside of the city. This is a city that was banking on the fact that the court would not clamp down on unconstitutional restrictions such as this, and immediately backtracks and changes the law when the Supreme Court, in fact, grants certiorari. Are we moving into an era where the courts are going to start taking Second Amendment claims more seriously? Let me just conclude by saying, I certainly hope so.
Thank you, Bob. Appreciate your perspective and your remarks. I think we'll shift gears a little bit at this point from the sort of historical observations that we've heard thus far to some more sort of, I think, doctrinal and theoretical perspectives. Let me first turn it over to Marianne Franks for your remarks, Marianne.
Great, thanks. Can everybody hear me okay? Good,
Yep,
thanks.
hear you fine.
So yes, I want to talk a little bit about the Constitution as a matter of culture, as a matter of political and social forces. And in particular, I want to talk about a theme that is sort of something I visit a lot, which is the theme of constitutional fundamentalism. And what I mean by fundamentalism here is the sense in which people take their very strong passions, their fears, their self-interest, and they attempt to, in effect, launder them through a higher principle. So instead of announcing, I want this policy, or I want these laws, or I want this to be the outcome because it benefits me personally, there is a very strong tendency, especially among Americans, to use the law as a way to justify that position, so as to hide, in some ways, the self-interests that are oftentimes driving policy and legal choices about, especially things like the right to bear arms. Also, we see this in the context of the right to free speech. And so I'm going to talk about that a little bit as being a pretty serious motivator, I think, when it comes to a lot of Second Amendment interpretation, and talk about what really seems to be driving much of the push for an ever sort of more aggressive, if we want to call it that, Second Amendment interpretation, more permissive gun laws, fewer and fewer restrictions, far more hostility to even really modest restrictions that are made on firearms. And I want to suggest that that is fair. It would be fair to characterize much of this push as an attempt to take the principle of fear and turn it into a constitutional principle. That the argument for so much of the guns everywhere movement is, we cannot possibly go to the store or to the daycare or to walk in our neighborhoods without the protection of a weapon. And the part that isn't said there very often out loud is because we're afraid, right? Because we fear everything that's out there, whether it's crime or whether it's natural disasters or whether it's other people. And that's very often, I think, the subtext is other people, and sometimes not the subtext. And so what we're really looking at here is a concept of self-defense that is filtered through the very limited perspective of guns. And what I mean by that is there's a very rich and easily justified way of looking at self-defense as an important concept that is not nearly captured in its richness or its diversity by the perception that guns are the answer for self-defense. Guns are a very emotional response to fear. They're in a very emotional reaction to perceived threats. They're a statement that a person is afraid in many contexts. So why is that so much of a problem? I mean, we can certainly imagine that people's motivations, their fears, their passions, all of this, these are things that everyone has. Everyone has certain types of ideas that they're more committed to. Everyone is prone to emotional vulnerabilities. What is the problem here if that happens to be what's driving so much of Second Amendment fundamentalism? The problem, I would suggest, is that what really gets you from passion to fundamentalism, from perfectly understandable to criticize, something we should criticize, is the concept of recklessness. That is, the elevation of your own self-interest and your own emotional state over the welfare of other people. And that is something that is a consistent theme throughout so much of the aggressive Second Amendment interpretation we've seen, for instance, advanced by the gun lobby. That is, it isn't about truly, you have the rhetoric that says, I want to be bold, I want to be brave, I want to defend my family and myself with this gun. But of course, what's actually happening objectively is you are raising the risk not only to yourself of being harmed, but to everyone else who has not consented to having that endangerment be part of their context. And so the real danger here is the recklessness principle, the idea that your selfish interests somehow trump the rights of everyone else around you, and that that is something that not only is justifiable, it is constitutionally, it is demanded by the Constitution and by faithfulness to the Constitution. Hence, so much of the rhetoric around the Second Amendment being, if you disagree with this, if you disagree with any part of that, you are not a patriot, you hate the Constitution, you hate freedom, etc. And of course, the objective part of the analysis falls completely by the wayside. You know, the empirical analysis of what guns actually do to protect people and what they don't do, how they're far more often and more likely to be used in illegal and antisocial ways than they can ever be used for socially beneficial ways. The fact that they're incredibly dangerous implements that most people don't have the skill or the training to adequately use or safely use. And the other thing I would say, just as kind of a background setter here, because there's a lot more to be said about that, is that principle of recklessness worries me from the perspective of the Supreme Court, not just in the firearms cases, because as many people have pointed out, we don't have that much to work with here when it comes to the Supreme Court's interpretations of what they really think the Second Amendment's boundaries are. If we look at a case from just a few days ago that's not about firearms, but is about government about government regulations on worship, right? The COVID restrictions in New York, the Cuomo case from just a few days ago. Here's something that you really can sort of read a lot into, right? You've got the majority of the court saying that these minor restrictions, these temporary restrictions in the name of public health for gathering in certain houses of worship, right? That those are committing such a grand and irremediable injury, right, that they cannot stand. And that the complaint of the people who want to worship the same way that they've always worshiped overrides any other public health concerns, right? So again, this isn't a case about guns, but you've got the majority saying, yes, we think that the First Amendment right to worship here is so effective or so powerful or so important that it completely overrides the expert opinions of those who would say, actually, you're going to be hurting people. And it isn't just a matter of taking a risk, again, for yourself. One can say, I'm going to go to church because if I die for my religion, so be it. That's all very well and good, except for the fact that not only might you die, but you may also infect others. You may infect the community you go back into. None of us actually is a self-contained unit. And therefore, when you take on that kind of risk, you also impose risk. So that particularly toxic combination of fragility, the sense of fragility about one's rights, whether it's First Amendment or Second Amendment, combined with this principle of recklessness, it doesn't matter that other people will get sick or die or shot because of my particular attachments here. That's the concern I think we should really have about this move in the last few decades, really to constitutionalize the concept of fragility and weakness, and to expect that that is a laudable and somehow noble goal when we're trying to protect that using the Constitution. The words that were used in the Cuomo decision by the concurrences, Gorsuch and Kavanaugh, criticizing the dissenters in that case and calling them essentially, traitors to the Constitution because they did not agree with the particular interpretation that they had about this. I think it reveals a lot about, I should say, this being the COVID pandemic, the approaches that people have to the First Amendment, the Second Amendment, they really can be read fruitfully in the context of what people are willing to do in terms of taking risks for themselves, when what they really do mean is imposing risks on others, and to what extent we're going to continue to allow the Constitution to be used as a kind of camouflage for exactly those types of tendencies.
Thank you, Marianne. And I very much appreciate your sort of bringing these issues into the current moment, both with respect, obviously, with the new court, but also just with the context of the pandemic and COVID. And I want to kind of explore some of these questions a bit more. First, though, I do want to give Joseph a chance to make some initial remarks. Before I do that, however, I do want to provide everyone in attendance with our code. As you have heard, there will be, for those seeking CLE credits, a form where you need to fill out codes for the particular panels. The code for this panel is CCJ FL3. So it's essentially the same as the previous code, but with a 3 rather than a 1, 2. Again, that's CCJ FL3. Let me now turn it over to Joseph for the final set of initial remarks.
Fantastic. Thanks, Adam. I first just want to thank our wonderful partners, David and everyone at NYU, Abby and everyone at Yale. You have been wonderful to work with pulling this together. Happy to see it come to fruition. It's great to see all of my co-panelists. I've known you all for years. It's really good to see you all here, even though, as Bob says, it would be much more fun if we could continue the discussion in person. Hopefully we can do that before too long. I want to keep my remarks pretty brief because I see that questions are starting to come into the Q&A. I hope people will continue to add more. I really just want to sort of, in some ways, riff off what Marianne just said, but expand on some ideas that I've been exploring in recent work with Abby's colleague, Reva Siegel at Yale Law School. And the title of the working paper we're working on kind of maybe explains what the basic idea is, which is recovering the common law approach to public safety. And the question that sort of motivates our paper is really a fundamental question that I think doesn't get asked or explored maybe as much as it should, which is the question of why regulate guns? Why regulate guns at all? That was actually a title of a shorter paper we published in the volume that Abby mentioned during the first panel. And in some respects, it may seem like an obvious question or a question with an obvious answer, which is like, we regulate guns because of the physical harm that guns can inflict if they're misused. And that is a perfectly sensible answer. As you've heard, as you know, about 100,000 Americans every year are shot. About 30,000 Americans every year die of gunshots, most of them self-inflicted, not all. Some of them shot on purpose, some of them shot by accident. I think that the sort of paradigmatic scenes that come to people's minds when you talk about gun regulation in that physical harm frame are familiar, right? It's Sandy Hook and Parkland and Orlando and Las Vegas, the mass shootings that the first panel had sort of discussed. And Reva and I take no issue with the importance of doing anything possible to reduce that physical carnage. But I think that the lives of guns, both good and ill, are more complicated than that. That's not just about bodies and bullets. Again, for good and for ill, the vast majority of defensive gun uses don't involve an actual shooting. Likewise, an enormous number, it's hard to know how many, of gun misuses do not involve an actual shooting. And when we expand the frame, I'll expand the frame that actually goes out of this frame to show, if we expand the frame to consider those kinds of harms, then I think the question of gun regulation actually looks a lot more complicated and interesting in ways that really have implications for how gun cases are litigated, to tie it back into the theme of this panel. Because then the paradigmatic scenes become not just Parkland and Sandy Hook, but what about armed protesters storming the Michigan legislature, right? What about intimate partner violence that doesn't involve the shooting of an intimate partner, right? The vast majority of gun-related domestic violence actually doesn't involve in the instant the pulling of a trigger. It is a pattern of coercive control. That's how we understand now domestic violence to operate. What about people who brandish or pull guns on each other when they're arguing about whether to wear a COVID-19 mask, right? Those kinds of incidents we think should also be part of the discussion about why we regulate guns. I think everybody understands and recognizes there's a government interest in public safety and that regulating guns can further that interest of public safety, but sometimes that interest is sort of equated with solely physical harm. And that's true in courts, it's true in legislatures, it's true in public discussion. Just to pull one example, CNN has a running story about where they tabulate the number of victims of school shootings over the last 10 years. And the number they come up with is 286, I think was the last time I checked. That's obviously counting only the number of children whose bodies were hit by bullets, not the thousands of children who were present in schools when a shooting happened or who've been traumatized by active shooter drills or anything else. The ripple effects of the violence and of just the threats and intimidation, I think, have to be part of the consideration as well. And to tie into the historical discussion from earlier, so that I can match Deepak on the references to the Statute of Northampton, I'll just say that this is nothing new. As I say, our project is one of recovering the common law interpretation of public safety. The Statute of Northampton prohibits carrying weapons to the terror of the people. Now, there are big debates about what the intent requirement is, and so on and so forth. But terror is the harm. It's not just carrying weapons so as to shoot other people. And by the way, that's exactly the common law tradition that Justice Scalia invokes in his majority opinion in Heller. Not just the Statute of Northampton, but many of the other sources he cites, albeit doesn't quote. If you actually check out the quotes, emphasize the same thing: longstanding tradition of regulating guns so as to prevent threats and intimidation. Now, this may seem obvious to some of you. I can't see faces. I don't know if people are nodding or rolling their eyes. Obviousness can either be a great virtue or a great failure of a scholarly project. But let me say that it is apparently not obvious to all, and that there are cases in which lawyers argue and judges have held that this physical harm principle is not just a sort of sufficient basis for gun regulation, but is actually the only appropriate basis for gun regulation. That when you conceptualize gun regulation only as preventing physical harm, then you go on to ask for a particular kind of empirical evidence. This is going to the means end scrutiny question that Deepak had referred to earlier, which may not be forthcoming for a variety of reasons, some of them having to do with funding, as Ala mentioned on the first panel, right? If the question is, can you show that this gun law by itself saves lives, then the evidentiary base is different than if you ask, does this gun law protect people in their, protect people's confidence in shopping, in worshiping, in gathering peaceably together in public places. And that, by the way, is how the court has conceptualized other kinds of constitutional rights. Here I'm riffing a little bit off of some of the earlier comments about Chief Justice Roberts. This is Deepak. Also, Chief Justice Roberts may be looking to borrow doctrines from other areas. I just happen to have right here, fortunately, a quote from Chief Justice Roberts in a First Amendment case called Williams-Yulee, upholding, while applying strict scrutiny, upholding a restriction on campaign contributions in the judicial context, in which he identifies the government's interest not just as preventing fraud, but in protecting public confidence. And he goes on to say, the concept of public confidence and judicial integrity does not easily reduce to precise definition, nor does it lend itself to proof by documentary record, but no one denies that is genuine and compelling. So our argument would be, if it's true that public confidence in judicial elections can be sufficient to uphold a law in strict scrutiny in a First Amendment case, what about public confidence in voting in a polling place where there are no guns, and so on and so forth? You can multiply examples from abortion cases where the court has identified as compelling government interest in the dignity of human life, in addition to deterring abortions, but just expressing the dignity of human life, so on and so forth. This comes up in legislative settings where, even before we get to litigation, where the precatory language of statutes, the debates about statutes are so often discussed as if they're only about preventing physical harm. This is true of the Lautenberg Amendment and other domestic violence-oriented restrictions, where the government's interest really is vocalized as if it's just about preventing shootings, when everything we've come to understand about intimate partner violence over the past few decades in particular is that it is much more than that. As I said, it's a pattern of coercive control wherein, and Susan Sorensen is the leading scholar on this, has pointed out that the vast majority of abusers don't fire guns when they're terrorizing their partner with them. All it's required is to show it, right? To actually just sort of demonstrate the gun. Now, I should say, and I see a question had already popped up about this, doesn't it go both ways? Can't gun owners also sort of assert, and this is going back to Mary Ann's comments, their interest in avoiding a certain kind of fear? And I would say, in some respects, the answer to that is yes, and they already do. The question is here, can there be a symmetry such that non-gun owners get to use the same kind of language? Here I'm quoting from a recent Ninth Circuit case struck down California's prohibition on large capacity magazines, wherein a judge says many Californians may find solace in the security of a handgun equipped with a large capacity magazine. Begs the question, what about those who don't find that solace, or who find whatever the opposite of solace is, terror or fear, so on and so forth? Gun manufacturers regularly tout, and this is quoting from a Beretta advertisement, protection, peace of mind, and self-confidence as the sort of tools, the sort of goods that are delivered along with gun ownership. Others argue, quoting from a scholar here, that gun ownership fosters personal and societal virtue. All of those, I think, are fair claims to make. My point is that there must be a symmetry here such that others can assert the opposite, that actually this is not a marker of virtue, or that this does not make me feel more confident in a public space. Both of those are constitutional claims which live within the same common law tradition. It's just that one of them, unfortunately, is sort of being, I think, is in danger, I guess, of being erased. And if it is, and if we fail to recover, or at least recognize this common law history of regulation, then I think we're in danger really of letting sort of guns define the boundaries of constitutional democracy instead of the other way around. So I'll stop there and happy to go to talk to the panel, rest of the panel, or to go straight to Q&A.
Thank you so much, Joseph. I think I'll start and use the moderator's prerogative to sort of pick up on what I think I'm hearing, especially from Joseph and Marianne. Marianne, you talked about sort of the boundary line, if you will, where, you know, the self-interest of somebody who wants to carry a gun sort of intersects with or has the opportunity to trump rights of others. And I'm also thinking about your remarks regarding the COVID case that the Cuomo case that we just saw decided by the Supreme Court. But this all comes at the end of a summer where, you know, we've seen a lot of incredible developments over the course of 2020, of course. But, you know, in addition to storming the legislative chamber, as Joseph described in Michigan, which has occurred in other states as well, where armed protesters have disrupted the sort of traditional legislative debate, causing, at least in the Michigan case, at least an adjournment of one session. We've seen fears of, though thankfully not realized as frequently as some worried, that there would be armed intimidation of those either casting ballots at polling places or, you know, counting ballots at some of where we've seen some loud and angry demonstrations, but thankfully not incidents of gun violence. But it occurs to me that some of these interesting constitutional questions are perhaps most clearly focused when we have not sort of abstract, you know, interests in avoiding fear or feeling secure or safe, but in exercising, whether it's the First Amendment right to peaceably assemble and demonstrate without fear of self-styled militia members, you know, getting involved in vigilante justice, whether it's the, you know, counting of ballots, whether it's the conducting of democratic debate. But I think we have all of these examples we've seen this year of sort of the First Amendment and the Second Amendment colliding in some ways. You know, I think probably members of the panel might come to different conclusions about the proper way to balance those rights and where the lines can be drawn. But I'm wondering in particular with the COVID case, what sort of signals that may give to us with regard to where the Supreme Court is likely to go. And I think let me turn first to Deepak, and then I'd invite everyone else to respond as well. But you know, in light of the Cuomo decision, in light of some of what we've seen sort of in current events this summer, I wonder where you might think that a court that has been so protective in a number of other contexts of First Amendment rights will come down when it comes to these sorts of intersections and opposing constitutional values.
Yeah, thanks, Adam. It's a great question. And I think I have been thinking a lot in the last few days about that New York COVID case. It is probably the best information we have about how this newly composed court wrestles with a really difficult and contentious constitutional question. And we saw some rifts develop in the court. We saw, you know, several separate writings, and at one level of generality, it bears a lot of similarity, as Marianne mentioned, to the kinds of questions we deal with in Second Amendment cases. On the one hand, you have public health. You know, you have the judgment of elected officials and public health officials saying that you need these restrictions to prevent the spread of a deadly virus. If whatever else you may think about giving deference to the judgment of the political branches in ordinary circumstances, you'd think particularly in a circumstance like this, there'd be a very strong case for that. On the other hand, you've got a constitutional right that where there is a perception that you know, particular people are oppressed, and there's a kind of cultural sense of oppression. I think of the speech that Justice Alito gave to the Federalist Society, where he, I think, equated both of these rights, that both of these rights are rights that are the free exercise right and the Second Amendment right are not taken seriously. So I think if you imagine that the same case were to come to the court involving gun stores, the arguments would look very similar, right? The question would be, are these restrictions generally applicable? And I thought there was a pretty strong case in the New York case that those restrictions were generally applicable. After all, other places where people were spending a lot of time together, like concerts or whatever, would I think have been treated similarly. And so I don't have a lot of confidence that when those cases come to the court, that the court will sustain those restrictions. I have not seen cases where we see a clash between the two rights set up in the way that Joseph is talking. I think this is sort of the holy grail of the litigation that we've been doing. We've been talking about this for a while, looking for a case where either there's a First Amendment right, like the right to peaceably assemble, the right to worship, whatever, that's set up in opposition to the Second Amendment right, or where there's a special reason to acknowledge those kinds of competing constitutional interests. We have a case, Ala and I do, in West Virginia, where we're dealing with a West Virginia law that restricts the ability of private property owners to exclude guns from their property, from parking lots. And we represent a coalition of domestic violence shelters in West Virginia. And that case, I think, is, it's not a Second Amendment challenge, but it's an effort to try to get the courts to recognize the constitutional value of the kind of competing interests that Joseph is talking about. I think we're a long way off from getting to a place where those arguments are, sufficiently teed up in the lower courts, have some doctrinal heft, and then and make their way to the Supreme Court. And I fear the court is going to be grappling with these issues much more quickly than the doctrine won't catch up.
Wondering if I might ask both Joseph and Mary Ann a question or make a point. You've spoken about the to some extent the costs of the Second Amendment and the consequences to people who perhaps don't want to participate in such or are afraid of those who are exercising the Second Amendment. I'm wondering, though, if you're ignoring the point that rights have costs, and we have developed, particularly the Supreme Court has developed since the Second World War, a particularly robust way of looking at rights and asserting those rights over and against potential costs. I mean, if we think of the costs that the Fourth, Fifth, and Sixth Amendment impose on us, where with the exclusionary rule, we have determined that people who are clearly guilty, but nonetheless there have been procedural violations of their rights, that evidence is going to be excluded, and we are going to essentially allow criminals to go free because of that. Given that we have developed that approach or that angle to dealing with that set of rights and other rights as well, are you in effect singling out the Second Amendment for second-class status, essentially taking the Second Amendment back to the 19th century police power jurisprudence, where almost any assertion of cost is enough to justify the restriction, something that we don't do in other areas, even other areas that can be quite costly.
I can take it first, Mary Ann, and then if you want to answer, I think absolutely not, in no way. And I think across a few dimensions, and maybe I should sort of reframe what I'm trying to say or try to restate it. Maybe in two ways. One, it's absolutely right. Of course, constitutional rights have costs, and just because somebody's harmed or feels afraid doesn't mean that you get to limit somebody's speech or other kinds of it. Absolutely, I think that's true. But I think it's wrong to think that, and again, this is why I was trying to quote from Williams U. Lee and point to a few other areas of constitutional law, to think that what I'm proposing, or I think what Mary Ann's proposing, is unique. This is how we treat other kinds of constitutional rights. You can't threaten a person with your speech and get away with it. There we have a true threat doctrine, which may be muddy, but at least makes that a carve out from the First Amendment. Why should the Second Amendment be any different? I'm trying to get them on an equal footing, I think. But I think the larger point is that it's a mistake. Bob, let me finish, Bob. I'll come, I promise. But But the real point, though, and this is the one that I think is just like most essential, is that it's a mistake to think about this as a right on one side and just policy interests or something like that on the other side. Like the main thread, the main thrust here is there are rights, constitutional interests on both sides. The sides of those who are asserting their Second Amendment right to carry a gun in their home or in public, I absolutely think that's true. As you know, like this is we've probably had maybe this exact debate before. As you know, I absolutely recognize that interest. What we're trying to say is that people on the other side are asserting constitutional interest as well, whether it's peaceable assembly or free exercise, or for that matter, the same personal safety interest that underlies the Second Amendment. And when that's true, then you can't just trump this one with this one. All we're trying to say, I think, is these two things have to be sorted out. It's not always going to be that every gun law is constitutional just because somebody's afraid of guns, but it also can't be the case that every gun law is unconstitutional just because somebody feels safer having the gun. And we should let Mary Ann respond to probably Bob before we come around again.
Yeah, thanks. This is I do think it's worth, I like the way that Joseph has put this. I mean, it's important to talk about how certain interests get constitutionalized and other ones get cast as sort of costs, right? And I think that that's where all the game sort of happens, is the idea that the gun is the right and everything around it becomes an externality or something that you just kind of have to think of in a secondary fashion. The thing is, I think it's right that the Second Amendment is being singled out, but exactly in the opposite way that you're indicating. It's being singled out as given more status than the other rights. Because, when we talk about the kinds of costs here, as I can't remember which justice it was in which case, but I think this is in McDonald where one of the dissenters says, the Second Amendment right as interpreted by Heller is different because it can kill people, right? That is it makes it very different, right? Exclusionary costs to one side, and we can debate the merits of the exclusionary rule in another time, but we're talking about the notion of irreparable injury. We're talking about the notion of losing the very right to your own life, or to feel constantly afraid of losing the right to your own life. That is not just a cost. That is actually an undermining every possible right we might hold dear, including our rights of free speech, including our rights to peaceable assembly, but also including our right to domestic tranquility, right? The whole social contract notion of what we've got here and what separates us from anarchy is you don't just get to respond to your own fears by shooting someone. You just don't get to do that. And the moment at which everyone becomes a law unto themselves, it isn't just that you violate people's rights to self-defense or you violate their rights to freedom of speech, which you do, but you also attack the very notion of a social contract altogether. You attack the very notion of democracy. And I think that that's what makes it different. And that's why the Second Amendment is getting special treatment, but for all the wrong reasons.
If I could jump in.
Bob, I want to very quickly, I want to get to you, Bob. Just really quick, I just want to say we've got about 5 minutes left for this panel. I want everyone to know that. Again, I want to give the code to folks. It's CCJFL3 for the CLE credit. And I'll go to Bob and David. If you have responses as well, I want to invite you to jump in as well.
Yeah, Mary Ann, your quarrel is with the right itself. What you're saying is this should not be a right. This should be something other than a right, perhaps a privilege, perhaps non-existent in civil society. That's fine. But it seems to me that the people who enacted it realized that one of the costs of having a right to arms is that there could be misuse and that people, in fact, might kill or injure others. I think your argument should be we should repeal this right rather than single it out. Yeah, say it's a right, but we're never going to enforce it. I think that's something very different.
If I could, thank you, Bob, and that I would agree with the point you just made. I think a lot of what we've been talking about here has been straw man arguments on the Supreme Court's decision about the Governor Cuomo's and the New York government closing synagogues and churches or drastically limiting their capacity. Just read the Supreme Court opinion. They're not giving the First Amendment free exercise of religion anything better than what businesses get. Their opinion is you can't treat people gathering for religious purposes worse than you treat them gathering to go to casinos or Walmart or other things. And it's also quite clear in the opinion, there was zero evidence that these plaintiff churches and synagogues, that there had ever been any transmission there because they were fully complying with all the previous capacity limits, had additional protections on top of that voluntarily. There was zero government interest in clamping down to say, for example, a synagogue can only have 10 people when it's got a capacity of 2,000, where some other business that has a capacity of 2,000 normally can have hundreds of people in it. And the same thing applies on the COVID litigation regarding the Second Amendment. A Massachusetts federal district court held that the governor can't unilaterally close gun stores when other stores can be open under reasonable restrictions. And for example, the district judge there said you have to have set up appointments, and this was at the height of the April and May wave of the epidemic. You can only allow one customer in at a time. You have to be by appointment. You can have various rules, but you can't treat the First and Second Amendments worse than you treat businesses that have nothing to do with constitutional rights. Of course, there are, as Joseph is absolutely right, that there are harms in gun misuse that aren't just solely limited to people who had the shots fired of them. And he talks about the secondary traumas of school shootings, which is exactly right. And of course, in domestic violence, as he also accurately points out, there's lots of domestic violence that involves brandishing the gun, for example, rather than actually shooting it. And that, of course, is already highly criminalized. And if a person is convicted of doing that, of merely making a threat with a gun, they'll be convicted of, at the least, a domestic violence misdemeanor and prohibited from gun ownership for the rest of their lives. What you can't do in a constitution that has a written text that guarantees the free exercise of religion and the right of the people to keep and bear arms is simply saying that your moral hostility to the exercise of the right and even genuine fears are sincere fears are enough. You can't prohibit the building of a mosque, even if 90% of the people in the community are genuinely afraid of Muslims, worry about Islamic terrorism and all those things. The constitutional text itself says some fears, however sincerely held, do not trump the long-term interest of a society that strongly protects the freedom of religion, strongly protects the right to arms. And the view of the Constitution is those are ways, those strong protections are life-saving by far in the long run, and are how you have a harmonious and civil society by not allowing people's fears and antipathy to people who exercise certain rights to be turned into law.
Thank you, David. And I do want to bring us to a close. I want to give Marianne a chance to respond to Bob's suggestion that there's a basic dislike or disagreement with the existence of the right itself. And the only thing I would say before turning it to you to close us up, Marianne, is just I think there are real questions. You know, okay, if Heller says there's a right to self-defense and in the home, one can have a pistol for self-defense in the home, and presumably that pistol can be used to defend one's property as well, to defend the home. Well, does that necessarily mean that one has the right to drive across state lines, pick up an AR-15 as a 17-year-old kid, and use lethal force defending some business property to which one has no connection? It strikes me as to say that if there's a right, without looking at the application of the right in different contexts and weighing the contours of it, it's a very imprecise way of talking about the situation. So we are coming to a close here. We're a minute or two over. I do want to give Marianne a chance to respond to your suggestion, Bob, and then we'll close it up. Thanks to everyone for participating in this terrific panel.
Yeah, thanks, Adam, and thanks for those questions. And this has been a really good illustration, I think, of what I'm trying to describe here as the deep attachments that people have and the kinds of identifications people will make of the feelings they identify with most strongly, the fears that they most identify with, and how those get presumed to be the constitutional status quo, and everything else is an attempt to modify. The idea of the Second Amendment being written by the framers as what is interpreted by Heller and MacDonald, I think just does not stand up to historical scrutiny. So we can argue about the Second Amendment as it was written. We can argue about the entirely new version, the living constitutionalism of Scalia, when he decided that it meant something else in 2008. In any event, I think what we always have to return to, again, as I think Adam is pushing us to, is to not think about this in the abstract and to not think about this in terms of emotions, because it's easy enough to say this is fear or that's a fear of a gun, et cetera. It's to look at something that's really unpopular in today's political climate, and that is facts. The empirical research is really clear that guns aren't good for self-defense, and they endanger not only the person who has the gun, but they endanger everyone around them. So if we're going to have a robust sense of self-defense, I'd actually agree that that's quite a good thing to have. It's essential to a civilized society, but the idea that the firearm equals self-defense has simply been disproven over and over again empirically, and therefore does not really work as an argument. It's merely emotional at this point. Now, when it comes to singling out Second Amendment, et cetera, I think it is important to just point out factually in the Cuomo case, because I think the COVID parallel is actually really quite interesting. As Sotomayor points out in her dissent, no, these places of worship weren't being treated worse. They were actually being treated better than movie cinemas and lots of other establishments that were told that they had to close entirely. So this wasn't just an instance of not only are you not being persecuted, churches, places of worship, it's also a case of you're actually being treated better and you're complaining about the better treatment and calling yourself a victim. And that really is as indicative or as characteristic of the Second Amendment movement as anything else. The notion that I call in my book victim claiming. You take the most privileged, powerful members of society, they have strong feelings about how they're no, in fact, they are persecuted. That's not based on fact, it's not based on evidence, it's based on emotion. But because they do have the power and they do have the sort of the imprimatur of the status quo, that's where we start having these debates and everything else gets scooted to the side as if it were merely some kind of a reaction to that. And that's exactly what I'm calling for, rethinking of that, rethinking one's own passions and emotions, et cetera, when it comes to this appeal to the Constitution.
Well, thank you very much, Marianne. I know we could keep going on this topic and many of the other ones that we have addressed during today's panel, but sadly we have run out of time. So thanks to all of the panelists, thanks to everyone in the audience. I'm sorry we didn't get to all of the questions that were submitted, but I hope you have found this to be as interesting, engaging, and informative a panel as I have. So thank you all. And now I think I will turn things back over to Peter to take us to the last panel of the day.
Okay.